So now we should talk about a special kind of analysis, which is often the cherry on top of good analysis, and that's making policy arguments. Just because things are legal doesn't mean they're right or just. A policy argument is looking to the aims of the law and saying that a result should change, or perhaps the law itself should change. So, this is something that you probably want to bring up anytime you think you've got the law right, you think you've got the factual analysis right, but the outcome doesn't feel right. It's not just. A policy argument is always a counter argument. You might say the case comes out wrong, so you're going to do something about it. In class, you are most likely given pieces of ammunition. For example, the professor might say the policy behind all of contract law is compensating people for violating their word. But a countervailing policy, as Oliver Wendell Holmes said, is that there's nothing inherently wrong about breaking a contract. The other party is simply entitled to whatever they bargained for. So that's generally the reason you can't get punitive damages for breaching a contract. That's the policy behind expectation damages in contract law. Or you might say that in the tort system, we should not compensate for mere words that are said except in outrageous circumstances. And that's the policy reason behind a claim like intentional infliction of emotional distress. And if you're talking about contract law, or you're talking about a torts hypothetical with intentional infliction of emotional distress, and you feel like the outcome isn't right, well, then you might use the policy aims behind that law, behind the discussion that you had in your class, to explain why the outcome should be different. And just as you're using legal concepts as defenses or counter defenses, you might use a policy argument to further your aim. It shows the professor that you are listening to their lectures, that you're listening to the reasons behind the actual law itself, and you're thinking deeper than just what are the elements that must be proven for a given claim. And when we see forks in the law, in other words, law that differs jurisdiction by jurisdiction, that fork depends on policy arguments. There's a policy reason why some jurisdictions use contributory negligence and some jurisdictions use comparative negligence. By and large, most jurisdictions rely on comparative negligence now because the policy or the aim of justice wasn't served by contributory negligence. So the bottom line is, if you feel like an outcome is unjust, that's probably an invitation to talk about the policy aims of certain laws and talk about the counter argument of policy. You're recognizing that the law is what it is, but that's not the end all be all. Laws can be changed. For example, one of the cases I was working on, one of the partners knew that he was going to lose the case. So midway through the litigation, we got the law changed, and it was retroactive. It was astonishing. Sometimes that's a good thing, sometimes that's a bad thing, but the law is not set in stone, and we shouldn't forget that policy arguments can be made depending on your standpoint, and sometimes you can get the law to change. That brings us to another core concept of analysis, which is using cases. Cases usually don't have black letter law in them. It's very rare, except in really old cases. We're talking 100, 150 years old, which, in law school, sometimes the cases are that old. They're just not going to have a clear and concise explanation of what the elements of a claim are, or what the elements of a defense are. But what cases are good for are for analogies. You're using cases for the fact situation that is discussed in those cases. It's one point of reference given the facts and a certain outcome. In the real world, there's really two ways that cases are used. One is a parenthetical, which is the citation to the case followed by the bare minimum that you're citing that case for. So it's a very specific point of law or a very small summary of the facts and the outcome. Uh, the other way that lawyers use cases is called a rule proof, which is where you state the case and then you run through a paragraph of the relevant comparisons between the case that's cited and the case that is before the court. As we discussed before in the section on what to do with cases in the regular school year, remember that it's a case that exists on a graph, and one particular case only gives you one point of reference. So if the facts had been different, the outcome might change. So you can draw an analogy to that particular case, but you need to recognize that if the facts were different, and in your issue spotting exam the facts will be different, that you can't always be sure that particular case is going to be the perfect analogy. Now, in using cases on the exam, if you can't remember the name of the case, just refer to it by the description. It probably won't hurt you at all. And in fact, some of the most famous cases are more well known by the quick summary of the case than it is by the actual parties. For example, if you told a torts professor about the eggshell skull case, he or she would know exactly what you're talking about. It's the case where someone had a medical condition where their skull was as thin as an eggshell, so a punch that would not hurt any person with a normal bone structure was catastrophic for this particular person. If there's a case involving fireworks, you can refer to it by the fireworks case. Sure, it's probably better if you can refer to a case by the actual party names, or at least one of the party names, but it's really not important. The most important thing to remember is the shortened version based on the facts. Those are probably the facts you're going to be citing anyway. But we always need to be thinking about the facts of a case on the X and Y axis. We need to think about if those facts were different, would the court have come out differently? You can always refer to a case as a negative analogy too. Say you have a case that comes out a person being liable based on the fact situation. And, obviously the person who wants to show liability can say, well, this is just like that particular case because this fact and this fact are the same. Well, you can also create a negative analogy. You can say this case should come out in terms of a finding of not liable because this fact and this fact are different. They're on the other side of the axis. So just because you have a case that comes out one way doesn't mean you can't use it on the other side. So always be wary of that. So for example, there is an old criminal law case, the People v. Stewart, where the defendants go on a 3-day drug binge and they leave their infant son to die of dehydration. And in that particular case, it's a terrible case, but it's a case where the couple, the parents, were found guilty of felony child abuse. Well, would that result be different if they had only gone out of the house for 12 hours? Maybe. Would it be different if they had only gone out of the house for 6 hours? Probably so. We're probably getting into different territory. What if they only went out of the house for 1 hour? Would they be guilty of felony child abuse for the child dying of dehydration? These are the kinds of questions, this kind of spectrum that all cases are on. And just because you have one point based on a certain set of facts doesn't mean that you can't use it as an analogy. And it also doesn't mean that you can't use it as a negative analogy or as a jumping off point to talk about how a different set of facts would come out in a different way. And again, when you read cases, always ask why. Ask what facts would need to change in order for the case to come out a different way. Don't marry your understanding of the law to a specific set of facts. Okay, so now is a good time to talk about essay organization. You want to use headings liberally to help your professor be able to read through your exam. The heading can and should be nothing more than the parties, the conflict pair, and the cause of action. So, for example, D may be liable for this cause of action. Or if you're in a contracts exam, plaintiff's offer. You don't need to write the issues to be discussed in the following discussion of the legal precepts as defined by Oliver Wendell Holmes is blah, blah, blah. Just state the law and move on to the analysis. You want to be writing short sentences clearly. These headings, which can be nothing more than the conflict pair and the cause of action, you don't need to state a conclusion. And really that takes care of the issue in IRAC, if you are going to use the IRAC method. It tells the professor what you're going to talk about. And when you go into stating the rule for the elements that you're going to discuss in the following paragraphs, in the RA paragraphs, or the RA paragraphs, well, then that takes care of all of your topic sentences. It doesn't need to be anything more fancy than that. Using headings and without any kind of precatory language also allows you to just start writing instead of wasting time on unneeded fluff. Also, often you're going to be using the same claims in the same fact pattern. Once you have defined the elements of a certain claim, say, for example, in the Elm Street hypothetical, you're talking about negligence as put forward by Drake, and then in another paragraph you're talking about negligence as put forward by Mary. Well, you don't have to go through them all again. You can just say element 1 of negligence is shown by this. You don't have to say element 1 of a claim for negligence is duty. Does an affirmative duty exist between the non-moving party and the moving party and the non-moving party? It's totally unnecessary. You've already defined it. And one thing you can do is use the Latin supra, which means what has come before. So you might say, start out a sentence by saying, regarding element number 1, as defined supra, and then go into your analysis. Anything you can do to save time by simply referring the professor back. We'll talk about some other tricks like this, but supra and infra are used all the time in legal writing. Supra means what has come before, infra means what comes after, so you're referring to something you're going to talk about. It allows you to skip elements that are obvious, and it allows you to avoid unnecessary discussion of rules that you've already talked about. All right, so let's talk about the language of good analysis. The most important thing that you can remember, by far, is to always ask why. Why does a certain fact support a given proposition? Why does a various legal argument flow from another? Drill down several levels. What you want to do is put because in your analysis. If you can use the word because, that is showing the logical link between one thing and another. Often you're going to be dealing with several different chains of facts. You need to show that this fact supports this argument because. Keep using because, keep asking why. That is a surefire way to make good analysis. Secondly, let's talk about the language of reality, showing that you are recognizing what exists in the real world. Well, that's language like suggests, implies, shows, demonstrates, generally, probably. All of these demonstrate that you're using what's been given to you. And again, making logical leaps. This particular fact suggests this conclusion. This particular fact implies this outcome. All of these words are great to show that you are making a connection between the facts as given and the point that you're trying to make. Now, one of the key phrases there is probably. If something is probable, then it's reasonably inferred from the facts. And that should always be part of your analysis. Remember, you're trying to get creative with the facts as given. And these are particular words and phrases that let you get creative. In other words, they let you see the implied connections between facts and the points that you're trying to make. Oftentimes, with good analysis, you're going to have to put forth the arguments that one party would make and arguments that would be used to rebut that particular contention. You're going to have to draw a line in the sand and come up with what the moving party is going to say. So that's language like will argue or would likely say. In other words, party one will argue this. You're putting a line in the sand that this party is advocating for this position. You're saying that it's likely that they're going to advocate for this next thing. It's demonstrating that you're recognizing that one party is going to make an argument, and then the rest of that sentence or the following sentences are going to rebut that contention. And then on the other side, you're going to say it all over again. You're going to rebut the counters by saying this party would respond to that argument by. That's the kind of analysis that your professor is going to be expecting. It's the kind of analysis that lawyers do all day long. You're teeing up the argument that the other side is making. Often you're putting it in a light that isn't most favorable to the opposing party because you're creating a kind of straw man. And then you're going to knock that argument down with your own argument and your own facts. So then there is the language of counter arguments. And we talked about this a little bit with Schimmel's idea of the ironic system of always howevering and neverthelessing. And I really like that, but there are some other words that you can use that mean exactly the same thing. But, yet, however, nonetheless, conversely, contrariwise, on the other hand. All of these show that you are countering the argument that was just brought up, and you are going to add your own spin on the other side. You're always going to have to go back and forth. And so there aren't enough of these synonyms to show that you are countering what was previously said and you're going to add on the other side. They're invaluable. Add as many of these and others like them to your repertoire as you can. On the other hand, there are words that you probably want to remove from your vocabulary in order to write good analysis. Those are words like clearly, obviously. Words that show that there's no argument should be used only in the rarest of cases. You never know in the real world if the judge actually agrees with all of the premises that you've laid out. And so it's never clear that a particular fact is a given, or that it's obvious, or that it itself is clear. So be very hesitant to ever use the word clearly or obviously in your analysis. So then there is the language of creativity. And as we talked about, you're going to use your common experience to add on to the facts so that you can talk about more arguments that are logical based on the facts that are given to you, but aren't necessarily obvious. They are implied facts. They are implied arguments. These are things that a court would take judicial notice of in practice. And we talked about the phrase arguendo, which means that you are adding new facts. It's synonymous with the phrase for the purpose of argument. If you are confused by something, you can use the phrase arguendo to show the professor that you're assuming something. It's a good cheat to not only to be able to get past something you're not entirely clear of, whether it's a legal argument or a factual argument that you're not 100% clear on. You can also use it to argue two different things. You can say arguendo if this fact is true, or you can say arguendo if the opposite fact is true. And you can show how that particular difference in the fact changes the result. That's the kind of analysis that your professor would really like to see. I'm sure your professor would be thrilled to know that the outcome changes based on a fact that he or she may not have included. So we've talked about the language that you want to use to have good analysis. But now let's talk about how to write more in less time. The tricks we can use so that when we are off to the races in writing, we're not writing as much as everybody else, so that we can focus more on more issues and more analysis. In the real world, lawyers use all kinds of tricks to write fast and legibly, and to cram more information into their brief. Practicing lawyers are often faced with both word limits and page limits. So anything that we can do to limit the number of characters that we're using, we're probably going to do that, because we always want to write more than the other side. It's just our nature. And there's a very good chance that your professor is either still a practicing lawyer or was a practicing lawyer at one time, or they read briefs from practicing attorneys. So therefore, any tricks that real lawyers use to shorten the number of words or condense the information, it's fair game, because your professor probably was a lawyer and will be familiar with legal briefs as they're written. As we talked about before, law school is slanted for the litigator. The first tip is more of a stylistic tip, which is to write short declarative sentences. Think Hemingway, not Joyce. We want short, choppy sentences. No commas, all periods. Don't worry about if your writing is poor. As long as it has a noun and a verb, you'll be fine. Just keep asking why, and write short sentences on why one particular fact proves the thing that you're trying to prove. And always ask why, so that you can dig another level deeper using short declarative sentences. We've talked about this a little bit. We want to use abbreviations for party names. Anytime you see a proper noun, the odds are you can abbreviate that into one letter. In the Elm Street hypo, we can use D for Drake. We can use M for Mary. We can use K for Kevin. Just use, the first time you do that, just use a parens after the name to signify the abbreviation. Real lawyers in briefs tend to write a paren with quotes inside. Not necessary. You don't need to write hereinafter, referred to as. Just write a paren and use the letter that you're going to use. Odds are the professor designed the test that way. They use these abbreviations. Sometimes it's P for plaintiff, D for defendant. Your professor will be very familiar with the abbreviations. And test taking is all about saving time. So there is no need to refer to the full name of the parties after the first time that you mention it. Just use the abbreviation. We've also talked about the idea of not repeating the law. Once you've stated the law in a particular question, then you don't need to repeat it again. You can refer back to the elements of a specific cause of action by just saying element number 1 for the cause of action, if that will save you time. Generally, you shouldn't need to repeat anything on a law school exam. If you are referring back to something, use supra. If you're talking about something that you know you're going to talk about in more detail later, you can use infra. Supra goes backwards, infra goes forwards. And it's great when you're using a laptop, because often you can copy and paste paragraphs that you've already written if necessary to have better organization. So sometimes, for example, if you've already defined the elements that are required for a specific cause of action, then just say as explained supra, or as we talked about the elements of this particular claim, supra, element number 1, and then just go into the facts that support element number 1. Now, we talked about not repeating particular statements of law, but you can also avoid having to create new analysis. If the analysis of someone's claim is exactly the same as another person's particular claim, then there's no need to repeat it. This often comes up when you're dealing in criminal law with a conspiracy. You have multiple conspirators, and odds are the analysis of whether someone was in a conspiracy or if they're guilty of a predicate act or the final act, the analysis is all the same between all of the different co-conspirators. If you have no new analysis to add, don't feel like you need to do the exact same analysis all over again. Just refer back to it with supra. You can say defendant X's liability for this claim is exactly the same as that as discussed supra with defendant Y, and then just move on from there, because the professor just wants to see that you know the issue and you can identify it, but then move on so you can talk about the real issues later. This is one of the few exceptions to the no conclusion rule. If you've already done the analysis, you can state a simple conclusion in this case and say the outcome is the same as what was discussed before. There is another great Latin phrase to be familiar with, and that is inter alia, which means among others. This is a great cheat if, one, you want to save time, or two, you're not really sure about all of the things that you need to talk about. So if you know one of the things you need to talk about, but you have forgotten the rest of them, you can say inter alia, and then what it is you want to talk about. So for example, one of the problems of this defense is inter alia, a lack of consent. In that way, you can hide the fact that you have forgotten what the other issues are, and at least get the points for the issue that you have spotted. And I'll use this as an opportunity to once again say, start writing early. It will cause you to see things that you didn't see before, and it will give you a head start on your fellow law school students. The less time outlining means more time to write, and as long as you have a general idea of the issues to be discussed, as long as you have found one claim and you have defined what the elements are for that, you can start writing if you want to. And also, I'll put in another plug again for practice, practice, practice. You can read all you want about how to actually effectively answer law school essays, but nothing is a better predictor of getting good grades than practicing as many practice exams as you can. You should start your practice exams before you think you're ready, before you've memorized all the law, because that will actually prime you to remember the law later. And writing essays is a skill that is separate and apart from actually knowing the law. So you have to do both. And as we talked about in the studying section, there are all kinds of ways that you can work with your friends in order to come up with good essays to practice the skill of essay writing, even if you don't know or haven't memorized the law itself. So that is the Eagle Eye system for issue spotting. It takes some time. You're not going to get it right away, but I promise you, the more you apply it, the more you will grow to love it, and the more issues you will spot. With practice, you won't have the problem of missing issues. You will have the problem of seeing too many issues. And at that point, you're in a good spot, because once you've seen the issues multiple times, you'll know what to do. And once you have practiced the art of good analysis and good essay writing, then it just becomes second nature. And you can actually get along by not doing the full essay, but once your writing skills have been sufficiently developed, then you can just practice with practice exams and just outlining. And that allows you to go leaps and bounds beyond your fellow law school student, because you'll be exposed to so many more practice exams, and you will get rid of your anxiety surrounding the test, and you might actually grow to enjoy the process. And the skills that you will learn in addressing all of the sides, seeing what arguments the plaintiff is going to make, and as well as the arguments that the defendant is going to make, it will be valuable when you're a practicing attorney yourself and you're able to see the chess moves many moves ahead. So don't despair if it seems like a lot of information. It is a lot of information, but the basic precepts are there. They are meant to be applied, and just go out there and do practice exams. And every time you do a practice exam, go back to these videos and the worksheets and remember all the different facets. Take slices through the facts. Never try to comprehend the whole. And then using the rubric that we came up with, apply different kinds of analysis and see if you can add on to your analysis with policy arguments once you've mastered the bases of the elements and the factual analysis, and then master the art of using cases in your answer. It's totally doable. It just takes some time, but you will be great at essays, and that really is the key to doing well in law school.